You tried calling P.O. Brayfield. I just tried and it hung up the whole system.
Okay, I will.
I don't know why.
P.O. Brayfield, if you can hear me, press *6 to unmute.
Hello?
I can hear you. We're just trying to connect to Hartford and then we'll get started.
Okay, thank you.
Good morning.
Good morning. Who are you here to see?
I'm here to see Mr. Irizarry and then Mr. Ortiz.
All right, 1 second. Don't like this one. All right, so the count just cleared, so we're getting them up right now, okay?
Thank you.
You're welcome. How you call it? Are you here for Felix? Yes. All right. He can't see you, but he can hear you. Can you see him now? There you go. All right, perfect. Over here, Skillet. Right here, Skillet. All right. That's from your right hand side. All right. If you
Good
hear.
morning, Mr. Irizarry.
Morning.
Morning. We're here today for your preliminary hearing, so we're going to begin with that, okay?
Okay.
Good morning. I'm Theo Meissner, hearing examiner for the Board of Paroles and Paroles. This is a preliminary hearing for Irizarry Lewis, number 297854. Today is February 11th, 2025. This hearing is being conducted via video at the BOPP Central Office in Hartford Correctional Center. This is a public hearing and public access. This hearing is available via video stream. Can you please state your full name and DOC inmate number for the record?
Alex Rangel Vasquez, inmate number 297854, formerly known as Louis Angel Irizarry.
Okay, thank you. And what's your number?
Inmate number 297854.
Thank you. And we have a parole officer present. Please identify yourself for the record.
Lisa Brayfield, parole officer.
And we have counsel here today. Please identify yourself for the record.
Yes, Hannah Dean from the Public Defender's Office on behalf of my client, Mr. Vasquez. Good morning, sir.
Morning.
This is a preliminary hearing, which is the purpose under Connecticut law. To determine if there's probable cause to believe you commit an act that violated the conditions of your parole, determine if the act was sufficiently serious to warrant revocation of your parole, and determine you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing and placing you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue probable cause and severity of the allegations. After the state is finished, counsel will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No.
Okay. You have important rights today. The right to have an attorney present. You have counsel here. You've received the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you for the hearing, and you have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes.
Okay, so we will now review the charge, state your PO is bringing against you, and the information underlying each charge. So PO Brayfield, you can please read the charges.
Sure. First charge, GPS. On 10/16/24, the offender signed the GPS monitoring agreement and was instructed 137 Ewell Ave, Bristol, Connecticut is an exclusion zone and he is not to be at the residence due to his minor son residing there. On 11/23/24 from 3:42 until 5:16 p.m., the offender was at the exclusion zone residence. The offender violated the GPS monitor agreement, which states, I will abide by all established inclusion zone requirements or exclusion zone restrictions and must obtain prior permission from a parole officer prior to changing any established zones. Program participation. On 1/14/25, the offender attended an intake at the New Britain AIC and was instructed he is to attend reasoning and rehabilitation group on Mondays and Wednesdays at 9:30 a.m. starting on 1/22/25. On 1/22/25, the offender failed to report for reasoning and rehabilitation group at 9:30 a.m. The offender's absence was unexcused. No contact with minors. On 1/19/25, New Britain PD was dispatched to the offender's residence at approximately 5:38 a.m. on a report that the offender pepper sprayed his roommate because his roommate woke up the offender's minor son. New Britain PD responded, smelled pepper spray, but could not determine who sprayed the roommate. New Britain PD stated the offender left the residence with his minor son. Therefore, the offender had in-person contact with a minor child without the express permission of his parole officer. Enhanced internet and device monitoring. On 12/23/24, the offender signed updated parole conditions with this condition added. The offender was instructed if he wants a device that has access to the internet, he will need to have monitoring software installed. On 1/24/25, the offender was found to be in possession of a tablet that did not have monitoring software installed. The offender's screen time analysis showed he utilized the tablet from 1/5/25 to 1/24/25 for a total of 102 hours and 33 minutes. The offender created a Facebook page with the profile name Tortuga Trickster and Discord page with the profile name Officer Tortuga Vasquez. Problem sexual behavior treatment. On 7/16/24, the offender signed the CTPSB treatment agreement in which he acknowledged he is restricted from contact with children under 16 unless recommended by CTPSB staff and approved in advance by his supervising officer. On 1/19/25, New Britain PD was dispatched to the offender's residence on a report that the offender pepper sprayed his roommate because the roommate woke up the offender's minor son. New Britain PD responded, smelled pepper spray, but could not determine who sprayed the roommate. New Britain PD stated the offender left the residence with his minor son. The offender violated the CTPSB treatment agreement by having unapproved contact with his minor son, which resulted in the offender's unsuccessful discharge from problem sexual behavior treatment. Should be noted the offender legally changed his name to Alex Vasquez, which is why the police report does not list Louis Irizarry.
Thank you. And the state is filed following exhibits pre-marked for identification purposes as Exhibit A, remand to custody, B, parole condition, C, parole violation report, D, notice of parole violation, E, AIC discharge report, F, CTPSB treatment agreement, G, misconduct, H, offender's ID, I, CTPSB discharge report, J, email from AIC, K, photos, L, GPS monitoring agreement, M, New Britain PD case incident report, N, Cellbrite data, and O is GPS event history. Did you receive notice of parole violation report, and those other documents that I marked? Did you review those, sir?
Me personally,
Did you
I did-
review the
I got-
documents?
I got the paperwork stating that those were exhibits. I didn't get the exhibits in their individual capacities.
Council received those and was
Okay, so you reviewed it with counsel at least, so you understand what you're being charged with, and you listened to the evidence.
Yes.
Okay. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses. So at this time, I'm going to swear in P.O. Brayfield as well as Mr. Irizarry or Vasquez. I'm going to swear you in so that you can speak today if you would like to. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes.
Yes.
Okay, so at this time, the state's going to have the opportunity to make a short statement or testify with respect to probable cause and the severity of the allegations. So P.O. Brayfield, if you would like to speak, this is your time.
Okay, I just want to make it clear that I explained to Louis many times that he is not allowed to have contact with his minor son, and that there was a process that needed to be followed in order to do that. And again, he wasn't remanded to custody when he first went to the residence. He was given ample opportunity to abide by his parole conditions.
Is there anything else you'd like to say?
No.
Okay. Okay, so now I'm gonna turn over to defense.
Thank you very much. For the first charge GPS, I argue that there's no probable cause. Although we do have a GPS agreement and evidence in the event history, there aren't any exclusionary zone maps that have been submitted, just the general report that says there was some sort of violation. But the GPS event history does not show my client's actual GPS points on the map. So I would argue that the probable cause is not there for that charge. For the second charge of program participation, I would argue that the probable cause has not been established either. My client reports that he did go to his intake on 114 and spoke to a staff member named Ian from the New Britain AIC. He was told at that point he needed to be in groups on 122 for 9:30 a.m. At this point, my client did raise with the intake specialist that he may not be able to make that appointment because he was typically reporting to parole at 9 a.m. and did have a reporting time on that date of 122 for 9. And due to relying on public transportation, he was unsure if he would be able to make it so close to the time of his appointment with his PO. So he indicates that he did go to parole on that date, 122, spoke to his PO, and explained to the PO that he has group at 9:30 a.m. But spoke to them, explained this, that he might be late. The PO told them at that point, my client states that it wasn't their problem, and that, you know, they weren't really generous about this conflicting schedule. At this point, my client indicates the PO told him that he should have come to parole earlier, but he didn't realize that parole was open and available earlier than 9 o'clock. He indicates that throughout his time, he had been reporting at 9 and was unaware that the office was open any earlier than for reporting. So he did go that day to AIC, even though he had missed the appointment due to being at parole. He said that Ian and AIC told him it's okay for him to miss the 122 group if parole calls and confirms that he was there. However, he indicates, despite, you know, explaining all this to his PO, they did not call and make that call for him. He does state, though, that he went regardless later that afternoon to the AIC on 122 and that they were able to reschedule him. He spoke to a clinician, I believe, named Christina to see if he could make up the session, and he was able to make the session up and did make it up, I believe, on 124, the morning before his remand. So I would just argue that PC hasn't been established for program participation. For the third charge, mental health treatment, I would note that on the 12/20 date, my client indicates he didn't intentionally fail to report. He took the wrong bus, realized it once he, got to the wrong spot, once he was on the wrong bus. And he did thereafter go to the program to explain why he missed the appointment to reschedule. And he said that the staff was very nonchalant, told him it was no problem, they were okay with it. And he reports that he did reschedule the appointment and attended that on 115. As to charges 4 and 6, I just want to note my client does indicate that this was not intentional contact, that this was incidental. He was home at his house. He was up early that day. His sister was out and about, was watching his son. She needed to stop and to use the bathroom before she was running some errands later that morning. And she called my client asking if she could stop by. He didn't realize, I believe at that point, that his son was with her. So I did just want to note that I believe this was incidental and it wasn't intentional contact. And as far as charge 6 goes, the device monitoring, I would argue no probable cause because nothing in the evidence establishes that this was my client's device. In fact, he indicates this device did belong to his wife who had left it at his residence. So I would just note that at this point, I don't think probable cause is established for that. And I would also argue, even if there is a finding that this conduct isn't serious enough to hold him, these are just technical violations, no new criminal charges. Thank you.
I'll be right with you with my findings.
Am I able to respond to that?
Yeah, this is your only chance to speak, so go ahead.
Okay. So regarding the GPS charge, I explained to Mr. Irizarry that he's not allowed to go to the wife's residence because his son lives, so he was aware. And again, that was, he was written a misconduct for that, and it was explained to him that he's not allowed to be there. That was not the, he wasn't just brought to jail based on that charge. The program participation regarding the AIC. So I met with Mr. Irizarry on January 8th, and I explained to him that he needs to see me earlier than the 9 o'clock time because group started at 9:30. So I told him to come see me at 8:30. He failed to do that. He came to report to me at 9:15, and I explained to him that, you know, you're going to miss your AIC group because you didn't report to me at 8:30 like he was instructed. The enhanced internet and device monitoring charge, the tablet was found in his possession when he was remanded. And, you know, everything on the tablet, it pointed to that it was his, including his Facebook page and the gaming profiles. And let's see. That's all I have. Thank you.
Thank you. All right, so I'll be right with you with my findings. All right, so I'm going to announce my findings. So regarding charge 1, I make a finding of probable cause condition GPS based on the evidence presented in support of the violation, which is exhibits B, G, L, and O. On charge 2, I make a finding of probable cause program participation based on evidence and testimony presented in support of the violation, which exhibits B, E, K, and G. On charge 3, make a no finding based on not being probable cause met, as was reported in testimony today by defense that the offender did reschedule and did attend that appointment. On charge 4, I make a finding of probable cause, no contact with minors based on evidence presented for the violation, exhibits B and M. I make a finding of probable cause on charge 5, enhanced internet and device monitoring based on the evidence presented and as well as testimony in support of the violation, exhibits B, C, G, K, and N. And I make a finding of probable cause charge 6, PSV treatment based on evidence presented, exhibits B, F, I, and M. I do find the acts are serious enough to warrant revocation. I determine you should be detained while you wait for revocation hearing. At the rev hearing, myself or another hearing examiner will determine if you violated conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked, what if any sanction should be imposed. You are a technical violation, therefore we have 60 business days to schedule your hearing from your date of return to custody. So it should be held in March to bring you back to determine if there's a violation or not. You understand?
Yes, ma'am.
Okay, so I will see you soon. Do you have anything to say?
We'll just set up another legal call with you prior to the revocation hearing and we'll discuss all of it more, okay?
And I gotta find out if you can get the watch that holds some evidence on it, some audio evidence.
Okay, I will call you before the hearing to discuss with you. All
Okay.
right, thank you, sir.
Okay, you're all set for today.
All right. Thank you so much.
Thank you, Field Brayfield.
Thank you.
Ortiz is next, correct?
Yes, please.
Okay, yeah. Three, 1, 5, 6.
Good morning, Mr. Ortiz.
Morning, ma'am.
Morning. I'll be right with you in a minute for your revocation hearing, okay?
Yes, ma'am.
I'm trying to find it.
Here's my opinion.
Yeah.
Usually. Is it,
Just need one thing.
oh, it's not.
I just have the other.
This-
Yes. All right, we're gonna get started. Good morning, I'm P.O. Meissner, hearing examiner for the Board of Paroles and Paroles. This is a revocation hearing concerning Ortiz Gregory, number 205717. Today is February 11th, 2025. This hearing is being conducted via video at the BOPP Central Office in Hartford Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Gregory Orlando Ortiz, 205717, ma'am.
You have counsel here. You can identify yourself for the record.
Yes, Hannah Dean from the Public Defender's Office on behalf of Mr. Ortiz. Good morning, sir.
Morning, ma'am.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weight your evidence must establish that, more probable than not, the allegation is true. But do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole. I'll reinstate your parole, which means releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your parole officer is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay. You have important rights today. Rights to have an attorney present. You have counsel here. You have right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, ma'am.
You have a right to view evidence against you before the hearing. You have a right to submit evidence supporting your case at this hearing. You have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
Okay, so we now review the charge that the state your parole officer is bringing against you and the information underlying each charge. So on charge 1, under restriction, absconder, your charging officer reported on 10/2/23. You signed out of the CPA halfway house to get your daily dosing methadone and failed to attend IOP at the Ruth Center. You're expected to CPA at 2:15 p.m. You failed to return to your only parole-approved residence on Washington Street in Hartford. Since leaving, you have not made any attempts to contact the halfway house or parole. Attempts to locate you via phone and in the Manchester area were unsuccessful. Charge 2, under bail laws of obedience to the law. Your charging officer reported on 12/8/24. You were apprehended by East Hartford Police. At this time of your apprehension, you had an active arrest warrant as prepared by Newington Police. Current charges were criminal trespassing first and larceny 6. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand to actual custody, B, PCS signed conditions, C, halfway house agreement, D, parole violation report, E, community partners in action incident report, F, notice of parole violation, and G is Newington Police Department signed arrest warrant related to case ending in 0365. Did you receive the notice of parole violation report, and those other documents I marked, and did you review those?
Yes, ma'am.
And counsel has filed the following exhibit that is pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for a parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we don't.
Okay, we have no witnesses. I will put on the record, I have received an addendum from PCS. The addendum reported on 11/7/2023, the BOPP did issue an absconder warrant for the offender. And on 12/18/2024, the offender was convicted of larceny 6, received a 90-day jail sentence. All their charges were nollied. So it's not a defense opportunity if you'd like to speak at this time.
Yes, I don't have any comments as to the standard for absconder. I just want to note that while in the community, my client indicates he was working and was attending to his medical needs. So he was, doing things to better his situation while he was out. And as to the obedience of the law, that is accurate. He took a sentence of 90 days on the larceny 6 charge. His max date for that is 3/17. And at the appropriate time, I would like to speak to his background and future plans.
Yes. All right, so what I'm gonna do next is I'm gonna announce my findings. So on charge 1, I do find that you violated the condition release direction absconder based on a warrant being issued by the VOPP and evidence that was provided in support of that charge, which is exhibits B, D, and E. On charge 2, I do find you violated conditional bail laws of the instant law based on your conviction of larceny 6 and received a sentence of 90 days jail. I do have an EOS date of 3/17/2025 for that, with the PED was 1/31/25. Or the TS date is 1/31. So that concludes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you. My client, Mr. Ortiz, is 49 years old, born and raised in Hartford. His support system includes his mother, his father, and his ex-wife, all of whom reside in Hartford. He has one adult son who he recently reconnected with, in addition to a grandson who he is getting to know. Most recently, when he was released from Osborne to special parole in September 2023, he was placed at Community Partners in Action's Family House in Hartford on Washington Street. Previously, while he was incarcerated, he did study business at Ashland Community College. He had lots of work experience, including working as a tattoo apprentice in Connecticut. He completed, I believe, over 2,000 hours and had his own business doing tattooing beginning in 2009 for quite some time. He also had work experience doing printer reprocessing cartridges at a facility in East Hartford. He previously engaged in treatment, including IOP and medication-assisted treatment at Root Center, and then did individual therapy every 2 weeks at the Way, the Truth, and Life Counseling Center in New Britain. He has an extremely significant medical history, which includes high blood pressure, endocarditis, MRSA, and one of the valves of his heart. And these require additional procedures in the future for him to move forward with those diagnoses. He underwent surgery on his spinal cord, C1, 2, and 3, and neck, in which he now has screws and plates as a result of a blood infection. Upon remand, he has been participating in the methadone program and the groups associated with that program. He does counseling through the mental health unit every couple weeks, and he is medication compliant. Upon reinstatement of special parole, he's open to being placed in a halfway house for the Connections Reach housing program in Hartford due to the closeness and proximity to his son and grandson. He would ultimately like to secure independent housing and enroll in a trade school to study welding. He's hoping to file for disability for medical purposes, and is also interested in getting back to tattooing or welding part-time. He's hoping to continue strengthening his relationship with his son and his grandson, and is open to any sort of treatment recommended, including successfully completing IOP, stepping down to outpatient services, and working with CCAR for ongoing sober support. He's also interested in participating in therapy with his son, who he wants to continue building his relationship with. His biggest priority right now is tending to his emergency medical needs. Those I previously stated, in addition to the fact that he currently is experiencing an infected blood clot in his lung that needs urgent medical treatment. So based on all of that, I would ask that he not be held past his max date of 3/17 for the new charges. These, I understand, are an absconding and an obedience to the law situation. However, the criminal matter has been resolved with 90 days only. And he was, working and tending to his medical situation while in the community. Thank you very much.
Thank you. All right, so I've listened to testimony today. I have reviewed all the evidence provided by the state. I will put on the record today. You do have a prior technical violation. There were no misconduct received. However, you were in the community for less than a month before you absconded from parole and were in absconding status for about 1 year and 2 months. You do have, according to our records, you have failed 5 out of 6 past releases to the community. And you are in special parole for 6 years until 2030. It is concerning that you continue to commit larcenies. You do have a history of robberies and larcenies, and you've continued this behavior. And you're on special parole now for robbery. You did receive a new sentence. So this behavior is concerning, the fact that you've absconded for so long and only returned to custody because you were arrested for committing the same behavior that you've been displaying for a long time. Based on this information that I have, as well as testimony, I am going to recommend that parole be revoked and that you be reparoled for June 9th of 2025. This is about a 6-month period of confinement as a sanction. I also recommend the following parole conditions: halfway house placement, no contact with your co-defendant, Caitlin Bildu, and mental health evaluation and treatment as deemed necessary. My findings are going to the parole board on February 27th. So this is a recommendation. The board's going to make the final decision. So they can lessen that sanction to as soon as 2/27. That is the soonest they can allow that. But they can also go longer. They can revoke all special parole, just so you're aware of that. Now you come back, the board can take all your special parole. So they do have that ability to do that. So I'm trying to put you back out in 6 months from your return to custody date. Do you understand?
Yes, ma'am.
Sir,
I
if
appreciate
you,
it.
if you would like to call my office on the 27th in the afternoon, we can let you know what the board decides, okay?
Thank you,
And
ma'am.
in the meantime, I did call medical for you. They said that you need to write them, okay?
I have
Okay.
wrote them, and I guess they have me scheduled for to see a heart doctor, but I don't know what's going on.
Okay, I can follow up. Thank you very much.
Thank you.
You're going to know on February 27th what the board's decision is, and you're going to get it in writing. About a week after, you'll get a letter from us that's saying what the board's decision is, as well as your conditions. And you can also speak to your attorney on that date later on to see what the decision is.
I would like to I'd like to say thank you for the opportunity to go back out there to both of y'all.
I just hope you make better decisions so you can address your health issues and do better out there. Okay?
Yeah, this time this
Take
really
care of
hit me
yourself.
hard. Thank you.
Thank you very much.
Thank you.
I'll see you in a little while.
Thank you.
Yeah, no problem.
Good morning.
Hey, good morning.
Hi, can I see Cornelius first?
Yeah, the other guy's not down here yet anyhow, but Cornelius is. Come on, Emma.
Thank you.
See, they can see you, hear you, you can see them. Right here.
Perfect.
That's good.
Thank you. Good morning, sir.
Okay, morning.
So I'm just gonna wait for all the attorneys. You can log on and unmute yourselves.
Good morning. This is Genny. Can you hear me?
Good morning. Yes, I can hear you.
Okay,
Perfect.
great. Thank you.
Do you know if the other, I know there's one other that is on.
Christina Gotsis also represents Mr. Cornelius. She's on, and I believe Mr. Creizman is attending shortly.
Okay, so I just want to make sure he was
Yes.
still attending because I don't see him.
Yes, he is planning.
Called Sullivan Finale. Yeah.
Good morning, man.
Good morning, how are you?
Good, thank you.
Good.
Is he finishing or I don't know why I'm going to. Who's that from now?
So it is 9:45, so as soon as Miss Attorney Creizman joins, we can begin. Do you know if he will be joining on shortly?
Yes, we are trying to reach him. We'll give him 1 minute, and then if not, we can proceed. Hold on, let me just see.
Hello, I just spoke with Attorney Creizman. He will be joining shortly, but he said that is no reason for us to not begin.
Okay,
Okay, great.
all right, so we're going to begin. Good morning, I am Board of Pardons and Paroles. The preliminary hearing concerning Cornelius Charles, number 296776. Today is February 11th, 2025. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing and public access to this hearing is available via video stream. Can you please state your full name and DOC inmate number for the record, sir?
Charles Cornelius, 296776.
Thank you. We have a parole officer present. Can you please identify yourself for the record?
My name is Parole Supervisor Micah Mann. I work for Parole and Community Services of the Department of Corrections.
Thank you. We have counsel here today. Can you all please identify yourselves?
Yes, my name is Genny. Last name is Ngai, and I'm joined by my colleague Christina Gotsis, and we both represent Mr. Charles Cornelius.
Thank you. So this is a preliminary hearing, which is the purposes under Connecticut law. It's to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure for the hearing. I'm going to read you your rights. Then we're going to review the parole violation charge that the state, your parole officer, is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue probable cause in the spirit of the allegations. After the state is finished, counsel will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin, sir?
No.
Okay, so you have important rights today. You have the right to have an attorney present and you have counsel here representing you. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
I don't have glasses in here. I think I got something. Yeah.
Did you review it with your attorneys?
Yeah.
Okay. You have the right to view the evidence against you before the hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
So you'll now review the charge of the state, your PO is bringing against you, and the information underlying each charge. So PS Man, if you could please read the charge.
Absolutely. On 12/26/24, New Haven Police Department executed a search warrant of a storage facility, storage unit at self-storage of Stratford that was in your name and that you had control over. Found during this search were several knives that are over 4 inches in blade length. Also found were switchblade and or metal knuckles. Your GPS placed you at this location as recently as 12/22/24. On 12/26/24, a search of your residence was conducted by Parole and New Haven Police Department. During this search, 6 knives, which are either over 4 inches in blade length or consisting of a switchblade and or metal knuckles, were found at your parole-approved residence in areas that you were able to access. All but one of these weapons were located on a kitchen countertop in plain sight next to your identifying information. This is a violation of your parole conditions. Specifically, I will not use or have in my possession or control any firearms, ammunition, or any other weapon.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, signed conditions of parole, B, remand actual custody form, C, notice of parole violation, D, parole violation notice, E, New Haven PD report, F, self-storage of Stratford customer information, G, risk protection order, H, photographs, I, Allied Universal event history, and J is State of Connecticut Board of Partisan Parole summary. Did you receive notice of parole violation report, and the other documents I marked, and did you review those, sir?
Yes.
Okay. And do you need to continue this hearing to obtain any additional evidence?
No.
Okay. We have no witnesses today. At this time, I am going to swear in Mr. Cornelius as well as PS Man, so that in the event you do want to speak today, you can. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Yes.
Okay, thank you. So at this time, the state has the opportunity, if they'd like to make a statement and testify with respect to probable cause in the sphere of the allegations, you may at this time.
Thank you. Very briefly, the state does contend that we have provided more than enough evidence to establish that there is probable cause that Mr. Cornelius did in fact buy and was in possession and in control of a large quantity of deadly weapons, most notably knives, as defined by Connecticut General Statute 53-206. The state also believes that these charges are serious enough to warrant re-imprisonment while he awaits his final revocation hearing based upon the similar nature of these charges to its very, very serious underlying charges, which also involves the illegal stockpiling of dangerous weapons, as noted in the evidence that we have provided.
Thank you.
Sure.
So it is now defense's opportunity to respond. If you'd like to make statements and testify with respect to probable cause and the severity of the allegations, you may at this time.
Thank you, and good morning. Officer, so, without making any admissions, we do not intend to challenge the specific exhibits, or even a probable cause finding that there were knives. However, we do object to any characterization that these were deadly weapons or that Mr. Cornelius poses any risk of danger or flight at this time, such that continued incarceration would be appropriate pending a revocation hearing. And we say this because there's been no evidence submitted by the state or by parole that Mr. Cornelius intended to use these objects as weapons. Okay, these are at best these shows knives. There's no implication or evidence to suggest that he used them to threaten anyone or to commit any violence or that he had any intent to do so. In fact, a lot of the exhibits attached show photos, but some of the objects could also be considered artistic objects. Some have ivory inlay in them. Some are collectible items. There's also been no evidence to suggest that he has any kind of malicious intent or ill will or present any signs of danger to the community. He's been on parole. He's been released on parole for almost 10 years. And there has been this is the only time that he has appeared before this board on an alleged parole violation. And I want to highlight that because the fact that Mr. Cornelius has not allegedly violated his conditions in the past is important because he's been on very strict conditions for almost 10 years. And this is in addition to private surveillance that's been conducted by a third party for almost 20, for almost all hours of the day. So this has been going on for a number of years. And I would say it's also counsel's understanding that Mr. Cornelius's direct parole officer, Erica Richardson, has even recommended, good performance or early termination of parole on several occasions before this alleged incident. I will also add that there's no reason why Mr. Cornelius should be detained any further because he doesn't pose any risk of flight. He's lived in the community, lived in the same home for the entire time that he's been on release. And any further detention would have negative collateral effects on his mother. He is the sole caretaker, full-time caretaker for his mother, who's 84 years old, and he provides for her care in all aspects. He provides her with transportation, he gets her food, he does the maintenance in the house. And so really, I think this is a very, this is a difficult hardship, not just for Mr. Cornelius, but also his mother, who, while he is being detained, waiting for the revocation hearing.
I would like to respond.
Sure, go ahead.
Okay. Couple of things. The defense counsel proposed that there's no evidence that the knives that were found are dangerous weapons. I just want to point out that Connecticut General Statute 53-206 is extremely clear in its definition of what is and what is not considered a deadly weapon when it comes to knives. Specifically, that statute says that switch knives or switchblades, automatic knives that have blades longer than 1.5 inches are considered dangerous weapons. He was in possession of that, and we have evidence of that. Not only that, but any automatic knife with a blade that is longer than 1.5 inches, the statute also defines that as a dangerous weapon. and any knives with a blade longer than 4 inches are clearly defined by statute as deadly weapons. In regards to that, there's no evidence that Mr. Cornelius was going to use those knives. I will point out that in his conditions, it clearly says that he will not have in his possession any other weapon, and it says to use or, not and, but or have in his possession or control. We have established clearly that A, those were dangerous weapons as defined by statute, and B, his there is probable cause that his that he was in possession and control of that. I will also point out that again, the state contends that this is eerily similar to Mr. Cornelius's underlying charges, in which he was also stockpiling large amounts of illegal weapons. So the state contends that whether he was going to use them or not, there is probable cause that he was in possession of them, and this is very, very similar to his underlying charges, of which he got a extremely long sentence, both on special parole and his underlying sentence incarcerated.
Officer, may I respond briefly?
Sure.
Supervisor, but go ahead. Sure.
Yeah.
At best, even assuming that the allegations were true, this is a technical violation. And I would disagree wholeheartedly that the conduct that is being alleged here is on point with the conduct that Mr. Cornelius has already been sentenced to, served his time, and is currently on parole for it. The facts are completely different. And I believe that we will put forth, distinguishing factors at the appropriate time for a revocation hearing. But at best, this is a technical violation. The state is pointing to, yes, legal definitions and the fact that there were knives that were found. We are arguing that even if there was a violation, this does not warrant continued detention pending a revocation hearing, because the state cannot point to any kind of statements, threats, or any other communications that Mr. Cornelius has made intending that he was going to use any of the knives as weapons, okay? And really, that's the core issue: is should Mr. Cornelius be detained for another 60 days, waiting for a hearing on this matter? And it's our position that there's no risk of danger and there's no risk of flight, and there are difficult and negative collateral consequences on his mother, who he is the caretaker for.
The state would highly disagree with almost all of those statements. And we will also, it should be noted that we will be submitting additional evidence for the final revocation hearing, which will show a increased threat of Mr. Cornelius. And so the state believes that there is way more than a preponderance of the evidence at this time to hold Mr. Cornelius while we await for that final revocation hearing. Counselor, you are absolutely correct. This is not a criminal violation. It is a technical violation. However, the state holds those technical violations as just as important as the criminal ones. And that is what we do every single day. And our job is to protect the public. And we believe that it is a complete necessity to hold Mr. Cornelius in order to do that and to protect the public at large.
Counsel, would you like to say anything else before I make a decision?
I would say, I understand all of the state's points. What I will say is that even if he were to be released today, he would still be subject to special parole conditions, which are significant and strict enough. But in addition, as Supervisor Mann knows, there is private surveillance on the defendant at all times that has been hired by Hopkins University. You have essentially both a state and private surveillance system on this individual who's monitoring his every move to understand and observe what he's doing. So if the concern is about risk of danger, there is enough on this individual to monitor any risk that he would impose.
Well, the state would contend that he has had this level of supervision for a very long time, and he still got away for I don't even know how long with the violations that we are bringing upon him today. So I believe that is not a most accurate statement, that the proof is really in the pudding, that yeah, he has been under pretty strict surveillance and still was able to stockpile a large number of deadly weapons. And so the state would contend that that exact argument is why he should be held.
If I may, I'd just like to add a point or two that the reason that for the search, what was tipped off was from what I understand from the police report, was a tip from the private surveillance that was hired by the Hopkins School. Review of the receipts and the allegations, again in the PO report, state that he had been collecting them at the very least from the last 2 years, 2022 into 2024. And again, he had been on parole and released for almost 10 years. And there was no allegation or tip from the private surveillance who tipped off about the weapons, and I use that in quotes because we don't agree there, that he had used them. In fact, I believe a large number of them, according to conversations with our clients, were still in their packaging.
Number one, we don't need to agree or disagree whether they're weapons or not. You can agree or disagree with Connecticut general statute. Number two, yes, that's true. And if we had received any information before when we did, then Parole would have taken action because we take it extremely seriously. But when we received the information, we took appropriate action, and we took appropriate action quickly.
Thank you. So is there anything else I would like to say before I announce my findings?
Your Honor, that's all from us.
Thank you. So I have listened to testimony on both sides of the state as well as defense that we have here. I have reviewed all the evidence provided by the state. I've listened to, as I stated, both sides of views from counsel in the state. I will note the offender will complete special parole May 17th of 2025 is the end date for the special parole, and he was on parole for about 9 years and 7 months before being returned to custody. Based on the information I have, as well as testimony that was provided today, I'm going to make a finding of probable cause on that charge number 1, condition obey all laws weapons, based on evidence and testimony that was presented in support of the violation, which is exhibits A and E through I. I do find the acts are serious enough to warrant revocation. I determine you should be detained while you wait for your revocation hearing. At the revocation hearing, myself or another hearing examiner will determine if you violated conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked, what if any sanctions should be imposed. I will note that it is 60 days from return to custody. So that started back in December. So he will be heard in March, by the end of March, for a revocation hearing. So we will schedule him, bring him back, and determine if there's a parole violation or not. Are all parties going to attend the revocation hearing?
Yes. Yes.
Yes,
Okay.
it will either be myself or Parole Officer Lindsay Karen. I'm Parole Officer Erica Richardson.
Okay, so I will note that, and we will let you guys know when the revocation hearing is scheduled for. So thank you to all parties for your information today.
Yeah.
Thank you for participating. Mr. Cornelius, we will see you soon.
Charles, we'll give you a call.
Thank you.
Thank you. Have a good day, everybody. You're all set, sir.
Yeah, now.
Morning, sir.
Morning.
Mr. Murphy?
Yes.
Okay, we're here today for your preliminary hearing.
Okay.
All right, so we'll get started with that in a second, okay?
Yes.
Good morning, I am P.O. Meissner, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Murphy Michael, number 387812. Today is February 11th, 2025. This hearing is being conducted via video at the BOPP Central Office in New Haven Correctional Center. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Michael Murphy, 387812.
This is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is releasing and placing you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is a reversal proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to address the issue, probable cause, and the severity of the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
I'll ask a question afterwards about my date, the discharge date. But everything else I know I'm guilty about. Hey.
Well, hold on. Let me get through this first. So you important rights. You right to have an attorney. Do you want to continue without counsel?
Yeah, I don't need no attorney.
Okay. You've already received the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence. You have a right to submit evidence for your case. This hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights? Now you're ready to move forward?
Yes.
All right. So now review the charges the state your PO is bringing against you and the information underlying each charge. Charge 1 is residence. Your PO stated on 12/24/24 around 2 p.m. Staff Roger Sherman halfway house were unable to locate you during count. A recount and search of the grounds was conducted in an attempt to locate you. Staff called your cell phone, as well as area hospitals, surrounding police departments, in an attempt to locate your whereabouts. PO notified at 2:15 p.m. you were missing from the program. This PO tried calling your cell phone on 2 separate occasions, did not receive a call back. This PO was able to contact one of your contacts, reported that they last heard from you by phone on Thanksgiving. On 1/23/25, this PO, along with the other assistants of the other parole officers, went out to the community in an attempt to locate you. On 1/24/25, around 3 p.m., you reported the New Haven District Office to turn yourself in. Charge 2, no consumption of alcohol. Your PO stated on 10/30/24 you consumed alcohol. Charge 3, halfway house placement. Charging officer reported on 12/24/24 you left Roger Sherman halfway house without permission, did not return. This violates your signed halfway house agreement. And on 12/23/24 you're found in the shower stall, fully clothed, smoking a cigarette. So the state has filed the following exhibits that are pre-marked for identification purposes. As Exhibit A, notice of parole violation. B, notice of parole rights. C, remand to custody. D, PCS conditions. E, halfway house agreement. F, the connection IR 10/30/24. G, the connection infraction. H, misconduct. I is misconduct. J is voluntary admission. K, the connection incident report. L, copy of falsified pass. M, the connection infraction. N, misconduct. O, the connection incident report. P, misconduct. And Q is the connection incident report. Did you receive the notice of parole violation report, and those other documents I just stated? Did you review them?
Yes.
All right. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses. I'm just going to swear you in so you can speak today. Can you just raise your right hand for me, please? You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
All right, so now is your opportunity to respond to parole violation charges against you. Well, remember that you may remain silent if you so choose. Would you like to, you can put your hand up. Would you like to respond to the charges?
Nah, I was guilty. But the smoking situation, that's not valid, but, I was in the bathroom at the time, but I wasn't the one smoking anything, but yeah, I'm everything else, consume alcohol and the pass and, leaving, yeah, I'm guilty for that.
Okay. Anything else you want to say before I announce my findings?
That's it.
I said, is there anything else you want to say? Oh, you said that's it?
Yes.
Okay. So I'm going to announce my findings. So on that charge 1, residents may make a finding of probable cause based on evidence and testimony presented, which is exhibits D and Q. On charge 2, and make a finding of probable cause, no alcohol consumption based on evidence presented in support of the violation, exhibits D, F, G, I, and J. And on charge 3, make a finding of probable cause, half-house placement based on evidence and testimony presented in exhibits D, E, O, P, and Q. So I do find the act serious enough to warrant revocation. Like you stated, you are done April 1st. So most likely you're just gonna EOS or your special parole. When that's completed on that day of April 1st, you'll just discharge.
Yes.
Because your 60 days is longer actually. So you're not gonna have time most likely for a revocation hearing. So do you understand that? Do you have any questions about anything?
Nah, that's it. I understand.
Okay, well, I wish you the best of luck, sir, and you'll be done, as I said, April 1st at 25.
Okay.
All right, so you're all set.
All right, thank you so much.
Good luck.
Yes.
Good morning.
Morning for Aponte.
Yes, please.
Okay, you can come in. Is when you're done, just click that one time and I'll come in. I'll hold it straight for you. Or you don't want anything?
I'm okay.
You sure?
Yeah, thank you.
Good morning, Mr. Aponte.
What I do?
Good, thanks. We're just gonna start in 4 minutes. I just gotta wait till 10:30, okay?
Fine.
All right, so we're gonna get started. We have your preliminary hearing, okay? Good morning, I am P.O. Meisier, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Aponte Carlin, number 218694. Today is February 11, 2025. This hearing is being conducted via video at the BOPP Central Office in Bridgeport Correctional Center. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Carlin Aponte, 218694.
This is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is release you and place you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your appeal is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to read the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
I do not.
Okay. Your important rights, the right to have an attorney present. Do you want to continue without counsel?
I do.
You have a right to receive the written notice of charges of violation. Did you receive the written notice?
I have.
You have a right to view evidence. You have a right to submit evidence supporting your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
I do.
All right, so now we will now review the charge the state your parole officer is bringing against you and the information underlying each charge. Charge 1, rebel law to be incident law. Your charging officer reported at 1:25:25 you're operating a motor vehicle in the city of Norwalk where you failed to obey a traffic signal and made an improper turn. You were stopped by Norwalk police who administered standardized field sobriety tests, which you failed. You were subsequently placed under arrest for the violation of a legal operation of a motor vehicle under the influence of alcohol, drugs, improper turns, and traffic control signals. On charge 2, weapons, your charging officer reported at 1:25:25 you're in possession of a 3.5-inch fixed blade knife in a sheath in the pocket of a jacket you were wearing, and an additional folding knife in the glove compartment of a vehicle you were operating. Charge 3, under additional conditions, no consumption of alcoholic beverages. Your charging officer reported on around 1:25:25 you consumed alcoholic beverage. The state has filed the following exhibits. Pre-marked for identification purposes as Exhibit A, Connecticut Conditions of Parole, signed 1/24/23. B, Connecticut Conditions of Parole, signed 6/13/24. C, Board of Pardons and Paroles Memorandum. D, remand to actual custody order. E, notice of parole violation, signed 1/27/25 and 1/31/25. F, parole violation report. G, Norwalk PD case insert report ending in 5263. H, judicial branch pending case detail docket ending in 0412-S. I, Norwalk Police Department property form. J, calls plus message 1:25:25. K, Norwalk Police Department case insert report ending in 28013. And L's offender misconduct report signed 5/14/24. Did you receive the notice of parole violation report, and those other documents I marked, and did you review those?
I did.
Okay. Do you need to continue this hearing to contain any additional evidence?
I do not.
Right. We have no witnesses today. So it is now your opportunity to respond to parole violation charges against you. However, remember that you may remain silent. I just need to swear you in under oath first so you could speak. Can you raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury.
I do.
All right. Would you like to say anything in regards to the charges that I read?
I'm guilty of them. That's it.
Okay.
Well, am I a chance to speak on it or?
Yes, I'm giving you the opportunity right now. Yes, go ahead.
I did start drinking about a month and a half, maybe 2 months before the arrest. And I didn't really know how to ask for help. Telling my parole officer that I've been drinking, it's an absolute violation. I've been a little stressed concerning housing and, you know, things in my situation. But I always maintain my job. I'm a delivery driver. My only defense with the knives, and I told my parole officer, and he just doesn't want me to carry them. But I'm in neighborhoods and that could potentially be dangerous. There's a lot of things happening to delivery drivers. You know, some get robbed and assaulted a lot, especially in my area. Also, I'm concerned about, you know, I'm in New Canaan and Darien and these, you know, these prominent neighborhoods where they have bears and coyotes now. I'm not used to this. So I'm a little kind of intimidated by, you know, I don't want to encounter a situation, you know, there's dogs loose and a situation where I can't defend myself. Yes, I do carry the knife, but the only one I'm disputing is the one that was in the sheath. That was in my glove compartment. The one I had, the other one I had on me. I have no reason to deny it. I'm not trying to fight it. One of the knives I had on me, the one you clip on, is in my belt. I've always had it on me. I wear it during work. I cut boxes. You know, I'm a delivery driver, so that's not my only job. I have side jobs I do, which is to break down, like, you know, a lot of boxes, and my hands get cut. Yes, I use a knife. then I'm not disputing that I carry it. But when I was pulled over, I clipped it off my belt and I put it in my glove compartment right here in this one. How did the one that was in the sheath go from there to my jacket pocket? That's the only thing I'm disputing. I'm not fighting anything. The one that was in the sheath was in my glove compartment over here. I can't even reach it. It's there. I don't even think about it. But the one I have on me, yes, I carry it on me all the time for safety reasons. I live in a criminal element. I came out of prison in a criminal element with the same mentality. I'm not running around like I'm not robbing nobody. I'm not doing anything. I'm not chasing people. It's purely for self-defense against any wild animals or anything like that, or potentially a robbery. I have a right to defend myself. I can't carry a gun and I'm not. And I know that he told me not to. He told me twice. I get that, but why does the police give them back to me? They're not illegal. And I have a hard time with that. I'm not gonna lie, I have a hard time with that. So I don't know, maybe you could tell me, I get it, but I've been out there 2 years. I've been out there 2 years working, doing the right thing. And towards the end, right, I started drinking like the last 2 months. I'm not gonna deny that. And I was kind of looking for help and I wasn't getting it. With housing, with a lot of stuff. And I got some stuff written down there. I'm on the waiting list for housing now, which kind of took the stress off. It's a program called CHESS, because nobody was helping me. Parole officer, he has been trying to help me with the housing thing. I had a meeting with Project Longevity. They denied me. They literally said I have to be sleeping on the street to get assistance. I don't agree with that because I'm about to be homeless. So I need somewhere to go. And I can't say that I'm homeless because I have to have an address to be on parole. Nothing is made really clear to me on that situation. My parents are moving. They're getting rid of the house.
Why didn't you get placed in a halfway house?
Well, to be honest with you, I really don't want to be in a halfway house. I'm trying to get out of the criminal element.
That's the thing. I understand that you don't want to be there, but if it's that or homeless, you need to be in a halfway house.
Oh yeah. When that time,
I mean? You need to go with whatever parole where they can find places.
Oh, absolutely. But I'm trying to. This is a preemptive thing because it's not going to happen right away. This is preemptive. I'm grown. I'm 48 years old. I want to be on my own, so I'm trying to seek housing wherever I. So there's a program called CHESS. That's an acronym. Somebody told me to fill out an application and I did. I filled it out and they said I qualified. I got past the first interview. There's somebody waiting right now to see me. But, obviously I messed it up. I got incarcerated. So I had somebody call them and tell them that I'm incarcerated so I'm easily fined because they said they'll come see me. So I could potentially have an apartment. So which is great. It'll take a little stress off of me because I have been collapsing it. This kind of been a rescue. This not been a rest. This has been a rescue because before things could get even worse or whatever the case may be, I'm glad that nobody got hurt. I'm glad I didn't get hurt. I'm glad it was just, it happened fast. I pulled right over. You know what I mean? And it wasn't like I was tripping over myself like that. Yeah, I drunk. But I don't, I'm not saying that I'm not making excuses at all. None whatsoever. I wasn't falling over myself and I wasn't, I was able to, still stay coherent drive. I was only going to get some gas and go right back home so I could have, gas in the car for my delivery job the next morning. But I'm not denying it. But
okay.
I definitely needed, I'm not glad this happened, but nipping in the bud because I do correct my mistakes. And I'm not ignorant. I still got my job when I get out there. They're holding my job.
Good.
So, there's nothing really, the only thing I know I need is with probably the courts is going to give me is the program. Every time I make a mistake, I correct it. So it's kind of been a blessing. It's not, it's not something that, I'm running from or denying. I'm not doing that. I'm not one of those. I'm pretty honest. But, obviously it's your decision.
Okay.
Do
you have anything else you want to say new that?
Well, I just want to know that I want to keep that work ethic. So I work in the kitchen now. I got a job in the kitchen. I've been in there for, a week and a half, 2 weeks already. I want to maintain that work ethic. And basically it, and I need to file my taxes. I'm not trying to make light of it, but I need to file my taxes. I need you to know that I got my LLC, I got my EIN number, and I'm starting to create my business. The next thing I need to do is create a website. And I got somebody to help me and take those steps. So,
Okay.
this kind of brought me back to focus a little bit. So,
Yeah, it sounds like you need to refocus yourself a little bit.
absolutely.
All right, so what I'm gonna do next is I'm gonna announce my findings, in regards to those charges. So on charge 1, I make a finding of probable cause, obey all laws, obedience to the law based on the evidence that was presented in support of the violation as well as testimony. This is exhibits B, G, and H. I'm making no finding on the 2 motor vehicle infractions as that doesn't meet the elements of the offense. And on charge 2, obey all laws, weapons, and making no finding of probable cause based on the behavior not meeting the elements of the charge. The knife blade is less than 4 inches. And on charge 3, I do make a finding of probable cause. Condition, no alcohol consumption based on the evidence and testimony presented in support of the violation, exhibits B and G. At the revocation, so I find that the acts are serious enough to warrant revocation. I determine you should be detained while you wait for your revocation hearing. So we're going to schedule you for a revocation hearing upon disposition of those charges. So when your charges get disposed of, we bring you back and determine if there's a parole violation or not. Okay?
So when I go to court and say they put me in a program, they say it's my first DUI,
And
they put me in a program.
they're going to communicate whatever happens at disposition to your officer, who then is going to let me know, and then we determine how we're going to move forward with that. Okay? So your main goal right now is to get those matters addressed in court and disposed of, whichever way it happens. And then we'll bring you back.
Okay.
Okay? So you're all set for now. Try to get involved in programming while you're in there
I
to address your
signed up for
substance
AA.
abuse.
I did. I signed up for AA. I'm on the waiting list.
It's good you're working in the kitchen, but you need some programming while you're in there as well. You know what I mean?
Absolutely.
Refocus yourself, attend AA meetings in there, which are available to you. And get involved in that, okay?
I did.
All right, I'll see you when you're done with those court matters.
All right.
All right, you're all set for today.
All right.
Good luck, sir.
Thank you.
Good morning.
Good morning. Morning, can you hear me?
Yes, I can hear you.
Okay, thank you.
Perfect. Thank you. Good morning, Mr. Rosario Torres.
Yes, hi, good morning.
Good morning. We're gonna get started in 1 minute, okay?
Yeah, ma'am, so there's a little bit of a problem because it doesn't look like my lawyer's here, and I contacted him several weeks before this hearing because he's been retained and paid for, and he's a no-show.
So what do you want me to continue this so you can try to attempt to speak to him, or?
I'm not gonna accept the deal that they're offering. I'm, as a matter of fact, I'm taking back my guilty plea from New Britain Court. I want to fight this. This lawyer just left me for dead. This guy's charging me $6,000, and he's done nothing for me. Nothing.
So your option is either to move forward today, or I can continue your case so you can try to talk to him or get another attorney. But that's all I can.
I'm not going to get another attorney. This attorney's been paid for. This guy's it's unbelievable what he's done.
All right, so do you want a continuance to get a hold of him so you can?
Yeah, ma'am. I have to get a hold of him. Because even in court, this is exactly, I'm getting blindsided. I went to court on January 9th, and we were supposed to speak. We spoke briefly. We stand in front of the judge, and everything that he argued for my defense was nothing.
Well,
I mean,
I understand. So I understand you have these personal issues with your attorney right now. As far as this goes, then, so you're telling me you want a continuance so that you can attempt to contact him to appear, correct? Okay.
Yes, ma'am.
So if I put you on my next hearing date, I believe is next week. Is that enough time?
Knowing him, I don't think so. I mean, he had me wait here. I've been in here. It's gonna
Because
be
I can
just
give you, the most I can give you is 2 weeks. I could give you out 2 weeks and do my next hearing date after that if you want.
Okay, because ma'am, I mean, okay, I'm at MacDougall. I have forms here that I put in for legal calls, and supposedly they called me. I can't even make a private legal call. I call my attorney from a recorded line. So I'm calling him from my tablet. I will do my due diligence to get a hold of him, but he's been paid for. You know, and the thing is that he's on the record as, because you're the same lady that we saw at HCC. So he was there in video court with you. He's on the record as being my attorney. At this point, it's ineffective counsel, unjust enrichment. There's so many improprieties and things that this guy's doing wrong at this time.
Okay, so but that's got nothing to do with us.
No,
That obviously I understand you have an issue. That's why I will grant you a continuance for those 2 weeks to figure out what you want to do. But I mean, either way, we have to move forward eventually. I can't keep continuing your case. But I will grant you. I'll grant you 2 out.
At this point, I might as well sit till 2026 and just max out, because this guy's doing nothing for me. Just give me back my money, because this is ridiculous. You know, this is what, if you want to keep me in jail, then fine. I lost my job, my apartment, everything. Everything that's on this VOP are lies. And all you need to do is
I know. I remember. I'm not, listen, I'm going to grant you the continuance so you can address this.
Next time I come in, just stay and I'll stay in
that's
person.
not how it works. I have to see you. So
Yeah. I mean,
I'm going to continue you out. I'll give you the 2 weeks at least. I'll hear you the way end of this month. So I'll let you have an opportunity to address that. Okay. So, and regarding Rosario Torres, Oscar 158633, I'm going to grant the continuance out at least 2 weeks. So you can speak and address these matters that you're talking to about your attorney. Okay.
Okay, so do you have a date? Do I put the date down, or I'll be notified, or?
You're going to be notified. We'll let you know when the new date is, because I have to double check. I want to make sure that I give you that to the end of that time, so you have enough time. Okay.
What do I do if?
I mean, you can, if you want I don't know if you were eligible for that public defender. I know you did that before. I don't know if you can be assigned.
He took. I paid him.
I don't know. I'm not an attorney, so
No, I understand, but I'm saying I paid him lots of money. He asked me for $6,000. I paid him close to half of that, and we're on payment arrangements. I'm a veteran, and there were just there are issues that
have him contact the parole. If you're gonna hold him, have him contact us. Tell him he's gonna file an appearance with us, and we'll put him on for the rep hearing. Just tell him to contact us.
Okay.
Okay, and then we'll get him, as long as he calls us and says he's gonna participate, we'll put him on and should have him here, okay?
Okay.
Right, so just address that. Well, like I said, I'm giving you at least 2 weeks, so.
Okay. Yeah, I just don't understand why he's on the record from 2024 as representing me. Then I got this paperwork from your office in Waterbury from the Board of Paroles, as stating that, there's nothing on there that he was CC'd. I don't know why he's a no-show.
Yeah, I didn't have him anything as appearing today. So all I need him to do is contact your office and say he's going to appear, and we'll put him on.
Okay.
Okay, that's it.
Okay,
So I'll see you soon. You're welcome.
Okay, thank you. Bye-bye.
Yeah, bye.
He's already done.
Yep.
Morning,
Morning.
Mr. Medina Delgado.
Yes.
So, I know that you applied for the attorney, the public defender. They did approve you. They didn't have time to review your case or do anything with you yet. So they said you'd have to schedule this out 2 more weeks if you would like to do it with the attorney. So you can either continue today without counsel, or I can continue your case out 2 weeks so that you have attorneys for the hearing.
Let's rock and roll.
You want to continue?
Yeah.
Okay. We'll get started then. All right. Good morning. I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is revocation hearing starting Medina Delgado Ismael, number 380081. Today is February 11, 2025. This hearing is being conducted via video at the BOPP Central Office, Carl Robinson Correctional Center. This is a public hearing and public access. This hearing is available via video live stream. Please state your full name and DOC inmate number for the record, sir.
Yes, my name is Ismael, ISMAEL, Medina, MEDINA, hyphenation Delgado, DELGADO, con number 380081.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. Now, this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay. Your important rights today, your right to have an attorney present, and you want to continue without counsel?
Yes.
All right. You have a right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you before the hearing. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes, ma'am.
All right, so now review the charge of the state your PO is bringing against you and the information underlying each charge. So on charge 1, restriction GPS, you're charging officer report at 11/27/24. You were placed on GPS monitoring. You were instructed to follow a home confinement schedule. You failed to comply with the GPS monitoring agreement and did not follow your home confinement instructions from your parole officer. On 12/8/24, you allowed your GPS monitoring device to shut down between 12/8/24, 9:57 a.m. until 12/10/24, 2:30 p.m. You failed to comply with your GPS monitoring agreement and did not follow GPS monitoring agreement number 4. On charge 2, under release restriction curfew, you're charging officer reported on 11/27/24. You're placed on GPS monitoring. You were instructed to follow a home confinement schedule. You failed to comply with the GPS monitoring agreement and did not follow your home confinement instructions from your PO. You failed to comply with the conditions on 12/7/24 and 12/8/24. On 12/7/24, you observed during review of your GPS on the Allied Universal Monitoring System not complying with the GPS agreement. You left home at 1:36 a.m., did not return home until 1:53 a.m. On 12/7/24, you observed during review of the GPS Allied Universal Monitoring System not complying with the GPS agreement. You left home at 2:15 a.m., did not return home until 2:56 a.m. Also on 12/7, you left home at 4 p.m., did not return home until 5:35 p.m. You left home at 5:50 p.m., did not return home until 6:54 p.m. On 12/7, you left home at 7:03 p.m., did not return home until 11:39 p.m. On 12/7, you left home at 11:46 p.m., did not return home 1:59 a.m. on 12/8/24. On 12/8/24, you left home at 2:40 a.m., did not return home until 3:04 a.m. On charge 3, obey all laws drugs, you're charging officer reported on 12/10/24. You admitted to covering officer that used heroin on 12/10/24. You signed a voluntary admission form on 11/27/24. You admitted to your PO you misused your Suboxone, used cocaine and fentanyl on 11/24/24. On 11/19/24, you admitted to your PO that you recently used fentanyl. You signed a voluntary admission form. On 9/10/24, you admitted to your PO you used fentanyl and overdosed on 9/5/24. You signed a voluntary admission form. On 9/4/24, you admitted to your PO that you used fentanyl on 9/3/24. You signed a voluntary admission form. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, Connecticut conditions of parole. B, Connecticut Board of Parole remand actual custody order. C, notice of parole violation, notice of parole rights. D, parole violation report. E, voluntary admissions. F, GPS monitoring agreement. G, allied GPS monitoring history GPS maps. H, app foundation letter. I, issued misconducts. J, decision information summary. And K is revocation hearing summary. Did you receive notice of parole violation report, and those other documents I marked? And did you review those?
Yes.
Okay. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses. So now is your opportunity to respond to parole violation charges against you. However, remember that you may remain silent. I am going to swear you in under oath today so that you can speak for the hearing. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, ma'am.
All right, so in regards to those charges I read, would you like to say anything?
No, I'm gonna stay quiet now.
Okay. So what I'm going to do then is I'm going to announce my findings based on the evidence that I have received by the state. So on charge 1, I do find that you violated condition GPS based on evidence provided in support of the charge, which is exhibits A, F, and G. On charge 2, I find you violated condition curfew based on the evidence provided, which is exhibits A, F, and G. And on charge 3, I do find you violating conditional bail laws, drugs, based on the evidence provided in support of the charge, which is exhibits A, E, and F. That includes the fact-finding portion of the hearing. Before I make a recommendation, you will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So in regards to going back out in your future plans, what do you have? What do you have planned?
Right now, I'm involved with CCAR, with a recovery coach named Ana Maria. I forgot how to pronounce her last name, but it's Spanish. I'm also waiting for Counselor Sanchez from Addiction Service for me to start the Vivitrol shots also, which I did write you, and I sent you a list of individuals that I'm still involved with at the Wheeler Clinic. I mean, like I already realized that, you know, legal leads to illegal drug use and so forth, back and forth. So for me to get back on track like I did before is to get back on the Vivitrol shot, which worked for me before. I do not wish to go back to doing what I was doing. As I wrote before, you know, I had lost my mother for Thanksgiving 2 years ago, and when I saw you last, I was overwhelmed, and the delivery was wrong. You know what I mean? I wasn't in the right state of mind. I was still detoxing and all that, you know. So that's why I rewrote you a letter, letting you know what was going on. It's not that I was on a rampage of self-destruction for 2 years. It's that I lost my mother 2 years ago. And, you know, every time like Thanksgiving gets ready to come around, I was like, you know, it was hard for me to deal with, you know what I mean? You know, sitting in the hospital, you know, for Thanksgiving and then, you know, just watching the life, you know, anyways. So, I mean, like now it's like, I want my life back. I want to get back on track. I haven't worked since July. You know what I mean? It's not like I said, you know, I gave you numbers. You know what I'm saying? It's like, I even wrote down giving them permission to talk to you if you decided to call them. You know, like I said, I've never lied to a parole officer. I'm not going to lie to you, you know, so, I mean, like, I know what I need to do. You know what I'm saying? It's like, you know, this is a wake-up call. I asked for help. You know, I already read your recommendation. You know what I'm saying? I mean, like, whatever you recommend, I mean, like, you know, it is what it is. I can't do nothing about it. You know what I'm saying?
Well, where do you plan on going when you get out?
I'm going to go back home. No, I'm going back home. I have a sponsor and everything. Go back home. My baby sister, go back home and just
Well, I need that. You want to go live at your sister's?
Yeah, where I was living at before, yes.
What town was that?
That's Hartford. 110 Mother Street.
What's your sister's name?
Stephanie Lynn Rivera.
So that's where you were before?
Yes, ma'am.
What's her phone number?
959-257-4595.
You plan on working when you go back out?
Yes, ma'am.
What do you plan on doing?
I used to deliver a sheetrock for a company called originally it was called Margem, and they got sold, and then that was called FBM. So it's all about just either getting back with them or just finding something similar to that. You know what I mean? You know.
Can you go back to them or no?
I mean, I can if there's something open. They would take me.
What was that company's name?
Foundation Building Material.
Okay. Anything else you plan on doing? Are you going to go to Wheeler Clinic to get?
I'm also gonna go to meetings. I'm also gonna get a sponsor, but I also want to do the CCAR training so that I could also become a recovery coach, because I feel that based on my experiences also that I can help somebody else. You know, like I said, I'm not trying to go backwards no more. I'm not trying to be, not be rebellious against parole. You know, I freaking regret it. You know what I'm saying? I should have just did what I was supposed to do, like I was doing the first 10 days. And I don't know, I just got overwhelmed and I don't know, I just freaked out a little bit and started rebelling, you know, so like I said, you know.
All right, is there anything else you want to add before I make a recommendation?
I guess that's it.
So I'll be right with you with my recommendation.
Okay.
Right, so I reviewed all the evidence that I have. I've listened to your testimony today. I am happy to hear you definitely sound better today than you did before. And I'm glad to see you have more of a plan going on about what you need to address when you get out. And I hope you stick to things. Things that you have told me today. You were in the community for about 3.5 months before your return to custody. You are on 8-year special parole. You do have a prior criminal violation that you received in 2022, as well as a prior placement in TOF. Your officer is recommending a year incarceration. You did receive 4 misconducts in that 3.5 month period. I will also note that these GPS and curfew violations occurred pretty much on 2 days worth violations. So it was only 2 days that those did happen. So I do take that into consideration as well when determining a recommendation. So based on everything I've just stated, I'm going to recommend that parole be revoked, be re-paroled for May 12th of 2025. This is about a 5-month period of confinement as a sanction. I recommend the following parole conditions: behavior management program for domestic violence, no contact with your co-defendant, Jill Pinto, no contact with victim NF, mental health evaluation and treatment as deemed necessary. My findings are going to the parole board on February 27th. So the board is going to make the decision on that day. So you'll know about a week after February 27th what the board's decision is. You'll get it in writing from the board. You'll have the conditions listed. Do you have any questions?
I already had did the domestic violence through the.
I don't remove it. It stays on there. If you already did it, unless something else comes up, then you don't have to redo it, but I'm not going to take it off if we don't remove those. Do you have any other questions?
No, that's it.
Okay, so you're all set for today then. Good luck. You'll know February 27th what the board's decision is. Okay?
All right, thank you.
All right, good luck, sir.
Thank you. That's it.
Yes, sir.
Hey, good morning, Ms. Leach, can you hear me?
Yes, I can. Can you hear me?
Jesus.
Perfect, yes. Maybe a PO Stratton?
Yes.
Awesome, I can hear you too. So we're going to get started with your revocation hearing, okay?
Certainly, yes.
Good morning, I am P.O. Meissner, a hearing examiner for the Board of Paroles and Paroles. This is a revocation hearing starting Leach Roberta, number 216425. Today is February 11th, 2025. This hearing is being conducted via video at the BOPP Central Office in York Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, miss?
Certainly. Roberta Ann Leach, 216425.
Thank you. We have a parole officer present. Can you please identify yourself for the record?
Parole officer Straken.
Thank you. We have counsel here today. Please identify yourself.
Yes, Attorney Hannah Jean on behalf of Ms. Leach. Good morning, ma'am.
Good morning.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which means releasing you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state and parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No, thank you.
Okay, you have important rights today, the right to have an attorney present, and you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
I do, yeah, yes. I'd just like to know if my attorney got the paperwork that had the witnesses or the references. I sent it in to you. I got something to fill out for you.
So I don't have any witnesses to call today. I'm just gonna go back through the paperwork. But I do have the exhibits submitted that we had discussed when I spoke with you.
Okay.
Yeah, I don't have any witnesses for today. I don't have the paperwork where that was indicated.
Okay.
Do you
I
want
had
me
given
to?
you like my ABH worker, advanced behavioral health. I had given all that to confirm that I was going. We are still involved.
Okay.
I call her once a week.
I have all the info that your social worker submitted, the social worker submitted.
Okay. I don't know who the social worker.
That was Miss Lopes. She spoke with you from my office.
Oh, yes. Okay. Okay.
Thank you. And we're prepared to go forward.
Okay. All right, so we will now review the charge the state your parole officer is bringing against you and the information underlying each charge. So, P.O. Strash, would you please read the charges?
Yes, good morning. Offender Leach signed her GPS agreement on 12/11/24. The first charge is GPS. You failed to properly charge your GPS monitor as instructed, allowing it to shut down on the following dates: 12/16/24, 12/17/24, 12/22/24, 12/23/24. You failed to return to your approved parole residence by your 9 p.m. curfew on the following date: 12/18/24. Second charge, obey the laws. On 12/1 into 12/2/24, sometime during the overnight hours, you hit a parked car on 415 Washington Street, Norwich, Connecticut, which subsequently led to your arrest on 12/5/24. You were arrested by Norwich Police Department for failure to drive right, 14-230A, violation and evading. Physical injury, -224B, misdemeanor. You were issued a misdemeanor summons, ME 016364, and released on scene on a $5,000 non-surety bond per Lieutenant Rankin. You were arraigned on 12/17 at Norwich Superior Courthouse, and you were given a new court date of 1/22/2025. Third charge, drugs. On 9/6/24, you reported to Norwich District Office and rendered a positive urine screen for cocaine and was confirmed by Premier Biotech Lab on 9/12/24 for cocaine. On 11/13/24, you reported to Norwich District Office and rendered a positive urine screen for cocaine and was confirmed by Premier Biotech Lab on 11/16/24 for cocaine. On 12/11/24, you reported to Norwich District Office and rendered a positive urine screen for cocaine and was confirmed by Premier Biotech Lab on 12/14/24 for cocaine.
Thank you. And the state is following exhibits that are pre-marked for identification purposes as Exhibit A, notice of parole violation, also included is parole violation report. B, notice of parole rights. C, remand actual custody order. D, PCS signed conditions. E, GPS signed agreement. F, GPS points. G, voluntary drug admission 9/6/24. H, Premier Biotoxicology 9/6/24. I, offender misconduct 9/6/24. J, Premier Biotoxicology 11/13/24. K, offender misconduct 11/13/24. L, Premier Biotech Toxicology 12/11/24. M, offender misconduct, 12/11/24, N, Norwich Police Arrest Report, 12/5/24, and O is Judicial Branch Court Case. Did you receive the notice of parole violation report, and those other documents I just marked for identification purposes, and did you review those?
Yes.
And council has filed the following exhibit pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. You need to continue this hearing to obtain any additional evidence.
No.
Okay, we don't have any witnesses. I did receive an addendum from PCS. The addendum reported at 1/22/25, defendant was convicted of evading responsibility, injury, damage, and received an 11-month sentence, execution suspended with 2 years conditional discharge with all other charges nollied. So now I'm going to swear in Ms. Leach as well as P.O. Stratton in case you would like to speak today. So can you please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes,
I do.
I do.
All right, so it's now the state's, if you'd like to present any evidence or speak to any of the evidence submitted at this time, you may.
Okay, this is me? Okay.
No, this is the state. No, this is the parole
Oh,
officer.
sorry. I'm sorry.
You're after that.
Okay.
So would you like to say anything at this time regarding the charges?
No.
Okay, so it's not a defense opportunity.
Yes, thank you very much. As to the first charge GPS, I spoke with my client about these different charges at length. As to the GPS charge, my client indicates that admittedly she is not very good with technology and thought that her device was working properly and was charging properly. She states that she didn't understand that there were low battery issues or anything until it was too late. She believes that she may have been equipped with a charger that was defective or maybe a device that had some sort of issue because she indicates the device never lit up or vibrated to alert her of the battery life or anything of that nature. She said in the only instance where the device vibrated, it was on the 2/18 date when she was about 35 minutes late on her curfew. But she said, except for that one instance, it never made any noise, vibrated, lit up, or anything like that. She also mentioned that in one instance, she was actually on the phone, I believe, with her PO, she indicates, while the device was plugged into the charger, and the parole officer at that point asked, what's going on with the device? Why aren't you charging it? And she advised them at that point it was currently on the charger. So she thinks that there may have been some sort of issue with that. She also does, I think, live in an area where she said the service could be a little spotty. So I don't believe these are necessarily intentional violations. I think there may have been an issue with the device based on what she explained. And as for the 2/18 late incident, she just wants me to know she was only late by about 35 minutes. And she did indicate that she had texted to notify that she was going to be late. The obedience to the law charge, it's accurate what you said, the disposition. She did get a fully suspended sentence with just a conditional discharge on one evading charge. Everything else got dropped. I do think it's worth noting the circumstances surrounding that incident. My client indicates that when this incident occurred, it was late at night and that she did leave a note on the vehicle in which she had gotten into the accident with. And she gave her information so that the owner could contact her about all of it, which back in the day at one point was something that, was more common to do, leave a note on a car if there was an issue. But she understands at this point that if this were ever to happen again, that she would need to stay on scene. But again, I don't think it was a situation where she was purposely trying to evade. But regardless, I understand that there is the conviction. And then finally, for the drugs, my client, it's unfortunate. She had been sober, I believe, for about 6.5 years. And unfortunately did experience the loss of her brother, which did trigger a relapse. She indicated that she disclosed this to her PO back in the spring of 2024 and was unfortunately struggling. So I will note, however, that despite that, she did successfully do ACT Foundation, but I believe maybe just needed a little bit more in the realm of treatment. So those are my comments as to the charges, and at the appropriate time, I would like to comment on her background and future plans.
Thank you. All right, so what I'm gonna do next is I'm gonna announce my findings. So on charge 1, I do find you violate condition GPS based on evidence that was provided in support of the charge, which is exhibits D, E, and F. On charge 2, I do find you violated condition, obey all laws, obedience to the law, based on your conviction of evading responsibility of injury damage and received a sentence of 11 months, execution suspended with 2 years conditional discharge, as well as exhibits that were provided by the state, A, D, and N. On charge 3, I do find you violated condition, obey all laws, drugs, based on the evidence provided in support of the charge, which is exhibits D as well as G through M. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose of this part of the hearing is to help determine what outcome I will recommend. So, P.O. Strahan, would you like to make any comments at this time in regards to her being released or background history?
No, I do not.
Okay. So I'll turn over to defense.
Yes, thank you very much. My client, Ms. Leach, is 64 years old, born in New Milford, Connecticut, raised in New Fairfield. Her primary support is her sister-in-law, Margaret, who she has basically doing work as her conservator of estate. Essentially, I'm not sure if that's actually through the probate court, but this her sister-in-law is who takes care of all of her finances, her survivor benefits, all of those things. My client also has 3 children, ages 46, 30, and 28. Upon her release to special parole in May of 2022, she did some time over at the Recovery 12 Sober House in New London. She was there for about 2 months at the supervised facility and then stepped down to the unsupervised facility where she was for about 6 months. She was then self-sponsored in Norwich at an address there. From September of 2024 until November 8th, she did the APT Foundation, which she successfully completed the inpatient program. Prior to the remand, she had secured a new apartment on Dell Avenue in New London, which she unfortunately ended up losing as she was remanded. For types of support, Ms. Leach was receiving survivor benefits from her late husband. She also was working part-time as a cashier at McDonald's in New London. She previously had worked part-time at Applebee's for about 15 months and then part-time at Chili's for about 2.5 months. Before completing APT, she had been doing outpatient services at Sound Community Service in New London for approximately 2 years. She also participated in outpatient services at Waterstone Counseling. She has a significant medical history, including vasculitis, chronic bronchitis, stage 3 kidney disease, and most recently, right before Thanksgiving, she reports that she suffered a mini stroke, which she did receive treatment for while at the hospital. She reports attending numerous appointments, including her primary care physician at Hartford Healthcare, a nephrologist, a neurologist, and a rheumatologist. Since she's been back at York, she's been working with a mental health clinician once a week for a half hour. She's also compliant with any sort of medications they have her on. Upon reinstatement to special parole, she's open to being placed somewhere in either the New Haven or New London area. She did update me that she had recently called Recovery 12, where she previously had great success, and they reported there was an available bed there. So I would ask if she is being able to go back to the community, that be considered first, and then the alternative, a halfway house in New Haven, Connecticut, due to its proximity to APT Foundation, where she had established services already. After successfully completing halfway house, she does have a housing program for life through the Thames Valley Council for Community Action RAP program. So she's hoping to get back to utilize that at some point. She's also hoping to return to her part-time position as a cashier at McDonald's in New London. She currently has another grandchild on the way. Her youngest daughter, I believe, is currently expecting. She's open to any sort of treatment, is hoping to re-engage with APT Foundation as well. And she would just like to note that if possible, she would like to be assigned a mental health parole officer just to understand some of the services that she needs a little bit more. So I am asking for Ms. Leach to be considered for release on the next board review date. That would be an approximately 2-month sanction. My understanding is that she turned herself in on this violation. Her court sentence is fully suspended and isn't currently holding her. She has, I think, a very good plan for maintaining her sobriety in the community with a mix of different types of services, individual therapy, plus some of the more intensive groups. She's also willing to be supervised by the mental health unit to help address some of her concerns and has taken it upon herself to try try and see about a bed at Recovery 12 to start her off on the right track. She also has a number of medical issues she's hoping to resolve in the community. And I think that her sobriety is going to be better addressed while in the community doing treatment as opposed to an incarceration. So I would ask for no more than a 2-month sanction. Thank you very much.
Thank you. All right, so I'll be right with you with a recommendation. All right, so I will put on the record, Fender was out there about 9 months before being returned to custody. This is her first violation on this period of special parole, but she was released to in March of 2024. She does has received 6 misconducts in that 9-month period, as well as a new conviction, which she received a suspended sentence. Based on this information, as well as the testimony that I have listened to today, I am going to recommend that parole be revoked. She be re-paroled for April 28th of 2025. It's about a 4-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health evaluation and treatment as deemed necessary, no contact with your co-defendant, Jawan Allen, operation of a motor vehicle. My findings will be in recommendations are going to go to the board February 27th. The board's going to review it that day. The board can lessen that sanction. They can also agree with me or make it longer. So you'll know what the board's decision is that day. You'll get it in writing about a week after with their decision. You can also talk to your attorney the day of February 27th to see what the board's final decision is. Do you have any questions?
No.
Yes, if you want to call my office on the 27th in the afternoon, we can let you know what the board decides.
Okay, I don't have your phone number. Right now I'm on the east side and I don't know, do they have your phone? Can you email the woman, Miss Knight? She's my counselor, Counselor Knight. And that's at North Dorm with your phone number.
Yes,
or
I
call
will.
through. Okay, and that would be on the 27th?
Yes, I won't physically be in the office that day, but if you call, one of the secretaries can let you know what the board's decision is.
Okay, and you'll you'll email the phone number, yes?
Yes, I will send that once I get back to my office today.
Okay, may I just say something? Okay,
go ahead.
I was making bad decisions. I was going through a lot. I realized that. I was so very happy for the 6.5 years I was sober. And that's what I want to get back to. So I appreciate the sanction that you are offering me. And that's it. Thank you.
Thank you very much.
Get involved in treatment as soon as possible, okay?
I will.
All right. So you're all set. Thank you, P.O. Strahan.
Thank you.
You're welcome.
Have a good day.
You as well.
Yeah. Great day. Enjoy your.
Yeah.